a tire blows, and your truck ends up on the shoulder. Nobody is hurt. Then a wrecker you did not call hauls it off. Days later the invoice arrives, not hundreds of dollars, tens of thousands. This is predatory heavy-duty towing. Right after a rollover, the trooper wants the lane cleared fast. So the officer reaches for a rotation list, a roster of towing companies called in turn, and dials whoever is next. The driver has no say in who shows up. That moment is where the problem begins. Here is the distinction that controls everything. A consensual tow is one you call and agree to. A non-consensual tow is ordered by police, with no consent from you. Owner-operators have shown lawmakers bills from $25,000 to over $100,000 for a single recovery. The line items can be staggering: a charge per pound of vehicle weight, a recovery fee for riding the truck, a hazmat line whether or not anything hazardous was involved, plus cleanup and crew labor. And underneath it all, storage fees that grow every day the truck sits on the lot. You might assume federal law caps the price. It does the opposite. Under Title 49 of the U.S. Code, Section 14501C, federal law generally preempts states from regulating a carrier's prices, routes, and services. But Congress wrote one exception. It does not cover tow truck operations done without the owner's prior consent. The Supreme Court reinforced that in Columbus v. Hours Garage and Wrecker Service in 2002. The court held that federal preemption does not bar a state from regulating tow truck operations, and a state may even pass that authority to its cities. So the question is not only federal law, it is what your state allows. Because states can regulate this, many do. A number publish rate schedules for non-consensual tows and require an itemized invoice. But these rules vary widely. What is capped in one state is wide open in another. So check the rules for the state where the recovery happened. Now for the leverage that makes this dangerous. The towing company holds a possessory lien. They keep your truck, and in many cases the cargo on it, until the bill is paid in full. That freight belongs to your customer, held behind a 5-figure invoice you never agreed to. That is how a tow becomes a hostage. So how do you fight back? One rule above all: never blindly pay, demand a fully itemized invoice. In one review, about a quarter of crash-related tow bills were not itemized at all, and that is where inflated charges hide. Compare the line items against your state's rules, because the rate may legally be capped. Then move fast, because storage fees do not wait. Notify your insurer right away, since many policies cover towing disputes. Bring in an attorney for unreasonable charges. Have drivers photograph the scene and note who ordered the tow. Groups like OOIDA have documented these practices for years. So here is the lesson. The difference between a consensual and a non-consensual tow decides what protections you have. Keep your itemization, check your state's rules, and never pay a shock invoice without challenging it. This is general information, not legal advice. Before you sign with a broker or carrier, look them up.